You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
Thanks for joining us on another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
Nice to have David back this week.
Yeah, it's good to be back.
Yeah, if you joined us last week, we were with Will Burns, our Director of Public Policy, talking about some of the different bills that have been filed this session and some things that we're going to be keeping an eye on.
Yeah, and I got to play with my two little 7-month-old grandbabies. It was great fun.
That's awesome.
Yeah, it was
Glad
great.
you got to do that.
Yeah, I am too.
Well, so what are we talking about today, David?
Well, we're going to talk about, or we have been talking about the fact that of judicial supremacy, but we've been talking about this marriage issue that's in front of us, and that 11 individual pastors and an organization representing several hundred more pastors all filed a petition for a declaratory order against the Department of Health back in December, asking if the state certificate of marriage that had been developed by then Governor Haslam following the Supreme Court's Obergefell versus Hodges decision on marriage, if that was a constitutionally appropriate exercise of power by the Haslam administration, the practice of which is being continued by the Lee administration, and whether or not Governor Haslam really had the power to assume that the state constitution was unenforceable and that the law defining marriage as a man and a woman had been changed to delete those words. So we've been talking about that for quite some time, and the governor's decision.
And the deadline was supposed to be tomorrow on the 18th.
Yeah, no, this is going to broadcast on Friday, but we're recording this on the 17th.
Yeah.
The decision by the governor as to what he was going to do. Was he going to defend Governor Haslam's action? Was he going to stop issuing certificates and say, I don't really know what the law is? Or would he tell us to proceed to court and actually sue him in court? That decision was due on the 17th because of President's Day. It was going to come in on the 18th, but I actually got the decision from the department Saturday. Yeah. So we know what it is. And I think it'd be good today to let people know what the department said, why I think it's actually good, although it's not what perhaps I had hoped for originally. I now think it's probably better than if what I'd hoped for had happened, and why I think it is better. And that relates to our Attorney General.
Yeah, especially in light of the response
from the Attorney General. So those kind of where I want us to go today. And I think what it'll do is it'll help put this notion of judicial supremacy and all this stuff in a real live context for people to see how it works and doesn't work.
So the Department of Health's response to our petition was pretty short and sweet.
That's right.
Essentially, they respectfully declined to issue a declaratory order, and expressed that we may file for a declaratory judgment. In other words, we're not going to do anything. You may proceed in suing us if that's what you'd like to do.
That's right.
So I could explain that a little bit.
Yeah.
Or it's probably not much more complicated than that.
Well, what the law does allow for is when a government agency does something that you think maybe is improper, they interpreted the statute wrongly, created a rule that, isn't really what the law intended, or in this case, created a form that indicates that the law's been changed. You go to the department first before you sue them in court and say, hey, I think you got this wrong.
Yeah.
Do you want to issue an order declaring this is now the right rule, or that rule's no longer the rule, or this form isn't the form, or whatever it is? So you give them a chance to fix their mistake. And they declined to issue an order saying, we're not going to do this anymore, or we're going to do something else. They just said, we're not going to issue an order. Now, one of the things they could have done is decided to contest my petition and say, no, we think we got it exactly right, and we're going to contest this, and we're going to have an administrative law proceeding in which you get an administrative law judge. And then you go through that for maybe a year. At the end of the day, both parties then have a right to appeal to the court system. And so that's just a long delay, but
Yeah.
the department has the right to do it, and they chose not to. So I'm thankful.
Glad they didn't do that.
I'm glad that the governor said we're not going to do that. And I think what he was in essence saying is, in reality, I'm not necessarily defending what the Governor Haslam did. I'm not defending what I'm doing, because I would contest you. I'm saying I'm not going to just voluntarily stop doing anything. Take me to court and let's have a court decide what the law is. What is the status, the state of the marriage license law in Tennessee? And that's, I take that as a good thing. I don't take it as the governor backing down or acquiescing to same-sex marriage or any of that, as much as it's saying there's a legitimate question here as to how the Supreme Court's decision in Obergefell versus Hodges, and in the Tennessee case that was a part of that, Tanko v. Haslam, how does that actually apply to the law of Tennessee? Nobody's ever applied it yet. We don't know how it applies. There are different ways to think about it. So let's just go to court and have a judge tell us, how to resolve this dispute between the ministers and the Department of Health as to what kind of form should be issued. So this is the way things are supposed to work. This is a great. This is what you do when you think there's a wrong Supreme Court decision. You don't just lay down and say, well, I think I'm going to go ahead and interpret it and extend it and apply it to all these other unknown situations. You say, well, I heard what they said in that situation, but now how does it apply to this one? So this is a very orderly process. But I'll admit my original hope would be that the governor would simply say, you're right. I don't really know what the law is either. No court has ever declared what I should be doing. And so until I know, I just won't do anything. I won't issue any more forms. I won't record any more forms when people file them back. And I told him face to face, I said, that would probably be my preference. You understand, though, you will get sued by LGBT couples who'll say, well, I want you to certify that my marriage is a valid marriage, and they will sue you over that. And then we would defend these principles of federalism, and we'd defend the separation of powers. We would defend our state law in the context of that lawsuit. And but we got an opinion letter from,
and we would have to trust that our attorney general would do that.
Yes, that's right. And
that's the problem.
Yeah, that's the problem. Right there, you heard it in a nutshell. That were we willing to trust the attorney general to vigorously defend our state's definition of marriage and our right to define marriage, and would he argue that the Supreme Court got it wrong or that it didn't extend to what we were doing?
Yeah.
And I don't have confidence that he would, because of a letter we got from the Attorney General recently.
Yeah, would our Attorney General defend the fact that the Supreme Court does not make laws for the state of Tennessee?
Yes.
They were not so sure.
Yeah, that's right. So now it puts us in the position of being the aggressor and not having to depend on the Attorney General to defend our laws. We will defend our laws by prosecuting the fact that the Supreme Court cannot change the statutes of the state of Tennessee. It has no power to change the statutory language of the state of Tennessee, and make the Attorney General argue that somehow the court does.
But we have an opinion letter right now.
Yeah,
that's
right.
That
he signed.
That he signed.
Well, excuse me, his office signed.
Right.
Yeah. That's right.
On his behalf.
On his behalf. That's correct. And let me explain the context of that letter.
Yep.
Representative Jerry Sexton, who's actually a co-prime sponsor of the Marital Contract at Common Law Recording Act.
In the House, right?
Yeah. That's right, in the House. He had actually filed a bill last year called the Natural Marriage Defense Act or something like that. And in essence, he was reenacting the statutes that we already have. And I said, we don't really need to reenact them because they've never actually been enjoined. No court's ever said you can't enforce them.
They still should be enacted.
So they're still enacted, and they should be enforced until some court says stop enforcing them. So it made sense for Jerry to write a letter and say, hey, did the court in Tanko versus Haslam, which was the lawsuit involving the governor, after Obergefell, did they ever enjoin the entire section of the Tennessee Constitution governing marriage? Did they enjoin the entire thing? Did they say you can't enforce any of it? Tell me, because I need to know. If they didn't, then maybe I don't need my bill, right? Then he said, and the second question I have is, did the final judgment in the Tanko case, did it apply to any county clerk who actually issues licenses? And because if it didn't, then our license law, again, is still valid, right? You would think until a court says you can't enforce it, it's still valid. So he asked those questions, and then the Attorney General gave us an answer, or gave him an answer back on, I don't know when it is. You've got the letter there.
It was December. Was it December 19th, I believe? It was dated.
Yeah.
January 23rd.
Yeah, January 23rd. Yeah, his letter was in December. And the Attorney General said, I can't really answer that question.
Yeah. Well, and he hasn't been listening to God, Law, and Liberty because he cited the Supremacy Clause.
That's right. He cited the Supremacy Clause. Why don't you just read what? So what he said is, I really can't answer these questions because they're going to be part of litigation that's pending against the department.
Well, he mentioned the petition, and then also said when most likely it's going to lead to pending litigation.
And I'm going to represent the department.
Which is fair.
Which is fair. I have no qualms with him saying I shouldn't opine on matters that I'm going to have to debate later.
Yet he went on
but he
and,
did go
and
on.
opined.
He went on and opined, which was good because he gave us some indication of how he thinks. So why don't you read kind of what he says?
Well, I mean, essentially, he stated that the Obergefell decision held that, quote, same-sex couples may exercise the fundamental right to marry in all states because the Equal Protection Clause of the 14th Amendment of the United States does not permit the state to bar same-sex couples from marriage. So first of all, he's acknowledging, in his opinion, that the Obergefell decision from the Supreme Court has changed the state laws of the state of Tennessee, and that this decision has given a fundamental right to marry, and he italicized in all states.
That's right. That's right. Yeah. So he's saying there's a fundamental right to marry. And then he mentions the Equal Protection Clause, and I don't remember if we had a podcast on it or not, but it was a commentary that the Obergefell decision either rests on the idea that you have a fundamental federal right now to marry. It's in the federal Constitution. Part of the word liberty means marry. In which case, if that's true, and he really believes that court opinions are the law and equal to the Constitution, then marriage is a federal issue. The Supremacy Clause applies. And Tennessee cannot pass a marriage license law that would affect, violate, interfere with federal marriage policy.
Yeah, we talked about that extensively. So our question is, well, so how do you go about getting a federal marriage?
So how do you get a federal license? Yeah. So then he goes on to this next point.
Yeah, so after,
and this is judicial supremacy on steroids.
Absolutely. And so after citing the 14th Amendment, he then goes in and says, secondly, the Supremacy Clause of the U.S. Constitution makes the holding of Obergefell binding on all states.
Yeah,
and then quotes the Supremacy Clause, and then italicizes some words. One being the Constitution. In other words, I'm guessing to say that the decision from the court somehow has edited our Constitution, which is interesting.
Yep.
He also italicized and highlighted the fact that it shall be the supreme law of the land. So I'm inferring that he's communicating that he believes that the decision in Obergefell made by the Supreme Court is now the supreme law of the land.
That's right.
And we should bow down to it.
He's equating an opinion and a holding, an interpretation of the Constitution as being equal to the Constitution.
Yeah.
That's not what the Supremacy Clause says. It just says the Constitution.
Right.
So
there is a way to amend the Constitution.
That's right.
It's not done in the courts.
It's not done in the courts. That's right. Because if they ever reverse an opinion, which they've reversed opinions before, they reversed holdings before, well, then you just said, well, they unamended the Constitution. They de-amended the Constitution. Oh, they amended it back. No. Yeah,
which we would have done over 250 times now in our history.
Yeah. So he says there's a supremacy clause, and then he cites this other case here.
Yeah, then he cites Marbury versus Madison, which he says holding that the Supreme Court is the supreme law of the land and is binding on all states. But that's not what that decision said at all. And
no,
you can explain that.
You know, in some ways, when people run out of reasons to explain why something's happened, a Christian, let's say, we might say, well, God's sovereign. And you retreat to God's sovereignty without trying to actually get at the heart of what might have happened here. And so when attorneys run out of places to go hide, they return to Marbury versus Madison. Oh, Marbury versus Madison said the opinions of this court are the law. Well, no. What they said is, we are the final interpreter of the Constitution when it comes to deciding how to resolve a dispute between two parties.
Which we agree with.
So, yeah, which we agree with. So Madison had a dispute over appointments that had been made by Jefferson. And so we wound up with this dispute over the filling of appointments as Madison, I think it was, left the presidency. And so there was a lawsuit over how do you fill vacancies in appointments and the tenure of appointments and all these other things. I didn't reread the case today, but the Supreme Court said, yeah, somebody's got to resolve this dispute. You know, you can't have one side saying, well, I get to decide it, and the other said, well, I get to decide it, because then they're going to both decide it in their favor. So we decide what the law is when we interpret the Constitution as to how it applies in this situation. But they were not saying that our judgment is, and our opinion changes the Constitution. It's an interpretation of what we think it means. It might not mean that. We might later decide we understood it incorrectly. It only binds the parties to that lawsuit. It doesn't apply to, you know, every other government official that might be implicated by those provisions. It was a very straightforward sort of case. Somebody has to resolve disputes as to what the Constitution means when two people can't agree on it.
Right.
That's what it stood for. But that's the bastion of that judicial supremacists run back to, and they extrapolate that decision out of its context to say, well, the opinions of the Supreme Court become equal to the Constitution. Now, there is another case that is very important, and I want us to talk about it today, and I don't want it to be confusing, but he has another paragraph there, and if you'll kind of read it, he cites this case.
He cited another case from 1958 called Cooper versus Aaron, and says that it establishes the principle that leads us to conclude that the finality and binding effect of the Obergefell holding on all states need not be established on a state-by-state basis by a separate adjudication to hold each state's particular statute or constitutional provision unconstitutional.
Right. Now, let me interpret all of that. What the court is saying here, and let me see, there was a law review article in Georgetown Journal of Law and Policy just last year, 2019, and it says this, the Supreme Court's analysis by itself does not directly bind non-parties. Okay, so the point is, I've issued an interpretation of the Constitution. It is binding as between you and me. But, and let's say you're the governor of the state of Tennessee, but it's not binding to the governor of Georgia or Alabama or any of the other 49 states. But he goes on in this law review article, and he says it's the collateral consequences of the court's decision that alter the status quo. So in other words, the court's not, when it issues a judgment against Governor Humble, it's not a judgment against, you know, Governor Miller and Governor Smith and Governor whatever of other states. But he says this compliance with it stems from an institutional respect for the Supreme Court. Practically speaking, such compliance avoids costly and futile litigation. In other words, we have the exact same law that was at issue in the case against Governor Humble. So Governor Kasich, whoever's the governor of Ohio, says, what's the point? My law reads exactly the same way. I'm going to stop enforcing my law too. What's the point? That's what happens with the abortion law. It's like, well, I got an abortion law just like the one in Roe. I got an abortion law just like the one in Pennsylvania at the Casey court. So the court has said to those states, your law is not enforceable. Now, it's not repealed. Only the legislature can repeal the statute. It's not amended. It's just saying, Governor, you can't enforce that law and prosecute that doctor. So the doctor in the state of Tennessee says, well, I'm not going to prosecute my doctors either. I'll wind up with the same result as a practical matter because I know that the court is the same and that's their opinion. So it avoids costly and futile litigation. I'm going to lose. Now, the Supreme Court can change its membership. And in which case, you may have not as judicial an activist a court, or you may have judges who don't believe in judicial supremacy anymore. And so you could take a different tact, or you can distinguish your case from the others.
I was about to say, we was going to harken back to that quote we had from Justice Scalia about, he said, don't just take it. Don't just sit down and take it. Just bring a new argument.
That's right.
And distinguish it from the argument you brought previously.
Sure. So you got Cooper v. Aaron in 1950, whatever I think he said it was,
1958.
58, okay. And you have Justice Scalia in 2013 saying, Lord, that was his words, an opinion so full of confusing rationale deserves to be distinguished. States distinguish away. And Aaron v. Cooper, the case that the Attorney General cites, in the concurring opinion, Justice Frankfurter even says this: even this court has the last say only for a time. Being composed of fallible men, it may err, but revisions of its errors must be by an orderly process of law. The court may be asked to reconsider its decision, and this has been done successfully again and again throughout our history. And so he's saying, okay, you bring me a different situation and say, well, here the facts are a little bit different from what they were with the Ohio law. Oh, well, if the facts are different, then maybe the analysis would be a little different. You see, how do we apply the constitutional principle of equal protection in this particular instance? How do we apply the due process of law in this particular facts situation? So the Attorney General is in essence saying states should not try to make any distinctions. They should not try an orderly process of doing exactly what Scalia said. Distinguish your law. Make a different argument. Come at it from a different direction. Don't just lay down and bow down to something that's silly and ridiculous and wrong. And so, to be honest, that's why I'm glad the governor did what he did. I don't want an attorney general defending a state law that believes the Supreme Court can issue an opinion that becomes, in essence, the general policy of the whole people and apply outside the context of the particular dispute that was in front of the court. I don't want that guy defending my law. I'd rather attack that guy. I'd rather make his arguments, make them look silly, make them seem inconsistent with the whole of our constitutional system and the nature of the judicial power. When we had our first lawsuit against the county clerk over in Bradley County, we wound up getting to the merits of the case for at least a period of time. And the Attorney General's argument came in. The statute says that the clerk may issue a license to the male and female contracting parties. Now, you and I, probably all of our listeners, know what a male and female is. But the Attorney General, to defend the issuance of licenses to two women, said, well, the word male does not have to mean a man. It could just mean a person.
Of course, which makes total sense.
Yeah. And the word female doesn't have to mean a woman. So the words are just simply interchangeable. And I could tell just looking at the judge, it was like, don't tell me that. And I got up and I pointed out, I said, Your Honor, did you notice that in the dictionary the word male is always referring to a man, even when it comes to flowers and animals? Never is the word male used to indicate, well, it could also be a woman or a female. And he said, yeah, I noticed that. So the Attorney General just made up this sort of argument that the word male, even though everywhere in every dictionary you ever go to, it's referring to a man. No, doesn't have to be a man. It could be a woman. It could be the female applicants. And I said, well, Your Honor, you can't rewrite the statute to say the male and female, the male and male, or the female and female. You can't rewrite the statute to say the male and female, or the male applicants, or the female applicants. You don't have the authority to rewrite the statute. But that appears to be the kind of authority the Attorney General wants to give to the United States Supreme Court to begin doing for the state of Tennessee. And I strongly, strongly object to that.
Yeah. We've got to be done with that type of thinking, honestly. And I can't remember. I was looking for. I was shuffling through my papers a minute ago. I can't remember where I read it. It was in one of these letters, but the Attorney General wrote. I won't be able to quote him, but essentially saying that I don't disagree with your plight. In other words, that. Yeah, I do believe that marriage is between a man and a woman, and
He said we're really sorry we lost that case, and we strongly disagree with that case.
But what bothers me is,
we're going to lay down.
Well, we're just not going to do anything about it.
Yeah. No, that was in the first. I think it was on the first pages of the letter, is that of the attorney general. But no, here it is. He says that. He said. We were, of course, disappointed in the Obergefell decision and in the companion case, Tanko versus Haslam. But, that's it. If there's a way to...
We're the state of Tennessee, and I'm the Attorney General, but, I have no authority. I can't...
Yeah, I'm not going to try to distinguish the case. I'm not going to try to argue anything about it that might distinguish us. And that's, to me, that's just kind of sad. It's abdicating the sovereignty of the state of Tennessee to 5 people in the United States Supreme Court. It's obliterating the distinction between the judicial function and the legislative function to assume that it's one thing for a court to say to a governor, you can no longer enforce your law. It's another thing to say, not only can you not enforce your law, but you now have to enforce it as if it was rewritten a different way without the legislature ever rewriting it, because we're going to rewrite it for you.
Yeah.
When we acquiesce beyond just saying, my law is not enforceable. Okay, I get you, Supreme Court. I can't enforce this law. To say, I must now pretend that I have a new and different law that we never enacted. That's a whole different kettle of fish. And it's just lawlessness to me.
Yeah. Well, I was reading something too. I came across a news article today. I know we're talking about marriage, but this same issue applies to abortion on the Roe v. Wade decision, and how we've completely just laid down to 9 unelected officials, on the court. But there's something happening in Iowa. There's a bill going through this year. It passed the Senate. It's currently going through the House, and it looks like it will pass. But they are, and correct me if I'm wrong, I think we did this in Tennessee at some point. They're working to amend their state constitution to put that there is not a right to an abortion per the Iowa State Constitution.
That's right.
We have that here in Tennessee.
Yeah, we were the first state to ever pass that. So I was the sponsor of that.
So,
actually.
And what year was that?
I filed it in 2001, and it finally went on the ballot in 2014.
Okay.
But I've been working with our counterparts, the Iowa Family Leader, and others in Iowa to draft that language, to make the arguments. I've been sharing with them our experience so they could learn, here are the pitfalls, here are the arguments that you're going to hear, here's how to answer the arguments.
Yeah.
So I'm glad to hear they're making some progress.
So it's passed the Senate, and I can't remember his name, but this news article quoted this conservative representative, and one of the things he said, he's like, we have abdicated or relinquished this power to the courts, and it's time we put the power of the ability to make legislation back in the hands of the people.
That's right.
And their representative government. And I was like, That's what I'm talking about. That's what needs to happen.
That's right.
It's time for citizens, legislatures of states across the country to recognize their sovereignty, but their ability to self-rule.
That's right.
And not by a court.
Yeah, I think maybe I'm mistaking it, but didn't you say that the gentleman quoted Abraham Lincoln?
Well, that was another
article.
That was something I came across today from Josh Hammer. He's the editor-in-chief at the Daily Wire, and he was doing an interview on the anniversary of Roe v. Wade, which was just a few weeks ago, and he was doing an interview with Liz Wheeler on One American News Network, and he was saying the same thing about Roe v. Wade, how we've bowed to judicial supremacy, and the idea that if every state just understood that if you don't abide by an unjust, horrible ruling, much same as Dred Scott, we've quoted Abraham Lincoln's inaugural address here several times about that decision.
Sure.
If states would recognize and just simply not abide, what's the court going to do?
Well, that's the thing. As the founders wrote, or excuse me, not the founders, but it's written in the Federalist Papers, the courts don't have force nor will. All they can do is issue a judgment and hope there's enough respect for the court system to abide by the judgment and do the judgment. And an official should. When you have a judgment entered against you, you should obey the judgment. If we just start saying, I don't care, then we've descended into chaos. But you can say,
except when it requires you to make slaves and kill babies.
Well, yeah, that's right. There are some things where you can say, either one, you need to remove me from office because I will not do this, or you find an orderly way to distinguish the situation, create a different thing, and go back and try again. You don't just lay down. You don't take a very narrow ruling like the Attorney General would do that says you can't enforce your law.
An unconstitutional ruling,
yes,
by the way.
and then expand it to not only say you can't enforce your law, but we're going to change your law de facto without you ever voting to change it. That's just horrible, in my opinion. And so, I hate that sometimes these issues come up in the context of, these divisive social issues of abortion and same-sex marriage. But the constitutional principles we should all care about. Because someday they get used against you and you're wondering, how did I lose my gun rights? Or how did I get forced into doing this or forced into doing that? Or some law I liked essentially is not only not just unenforceable, but it's been rewritten by a court. How did that happen? Well, it happened to you. Now you're going to care, right? So we need to understand these are huge issues, not just morally or theologically, but constitutionally, that need to be fought. We need to say judicial supremacy is a myth and call their hand on it and pass a law that forces the court to re-examine that decision. And that's what we were hoping the governor would do, is to say, I'm not bound to do anything by an order that doesn't affect me. County clerks are not bound to do anything by an order that isn't directed to county clerks. But what we've seen is our attorney general say, "Oh yeah, you should just bow down and do it anyway," even if it violates the Tennessee Constitution. It's never been enjoined. Even if the statute's never changed, just do what the court says, and we'll all be happy. Well, no. That doesn't work for me. So anyway, I wanted people to understand we're going to move. We'll be filing this lawsuit against the department on behalf of these ministers and getting after it. And I'm ready to go. I'm excited. Let's do it.
And so that said, worth noting, look, we're a nonprofit here in Tennessee, and as the CEO, I write checks and also happy to receive checks.
That's right.
That's right.
So
we're about to get into a new season here on taking on some very large issues, and so you can check out FACT Tennessee, FAC Tennessee.org. and find out more about what we're doing. And there's opportunities there to subscribe to our newsletter and also to give to our organization as we fight the good fight and let people know that we're not ruled by a court.
That's right.
We left England and we wrote a constitution and declared that we rule ourselves.
That's right.
And that's just kind of the way we do things.
That's right. It's time to get it back.
Yeah. So as always, if you've got questions, comments, we'd love to hear that. You can email us at info@factn.org. That's FACTN.org. And make sure to visit our website at factennessee.org. Thanks for joining.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram at FactTennessee.